If you're the subject of an investigation with the SEC or CFTC, do you get attorney-client privilege with regard to communications with lawyers who work inside your company? The answer to that is not so simple. Communications with an attorney are subject to attorney-client privilege if the person the attorney is talking to is the client. But if you are at a broker-dealer, an FCM, a swap dealer, who is the client? The client is the company. So the lawyer works for the corporation. The client is the corporation, not any of the employees. Therefore, if an employee talks to an attorney who works at the company and admits to committing a crime, the attorney can go around and tell the board of directors, can tell management, can even tell authorities, because what the employee told the attorney is not privileged because he or she is an attorney for the company, not for that employee. There are other instances where this comes up very often. Let's say that you're the subject of an investigation by the SEC or CFTC, and you've heard that one of the things that the SEC considers when deciding what type of punishment the company should get is the amount of cooperation that you provide. So a company that goes above and beyond what is required in the investigation to help them set out their case, the SEC will take that into credit. Neither the SEC or CFTC will require you to waive privilege in order for you to get that cooperation credit. But they will also absolutely hold it against you if you try to claim privilege where it does not exist. So where does that come up? If the attorney is providing legal advice to the corporation, then that advice and the communication surrounding that on both sides are privileged. However, if the attorney is providing business advice or financial advice, that information is not privileged because in that role, they are not providing legal counsel. They are providing business advice or financial advice. So that communication is not subject to the attorney-client privilege. And the place where it comes up the most often is during an examination by the SEC, CFTC, or one of the self-regulatory organizations like the National Futures Association or FINRA. And broker-dealers, FCM, swap dealers will routinely claim that somebody who works in the compliance department or other department, accounts payable, accounts receivable, IT, is subject to attorney-client privilege because they're an attorney, and they absolutely are not. If you are in a legal department and you are performing a legal role, you get attorney-client privilege. But if you are in a non-legal department performing a non-legal role, just because you are an attorney does not entitle you to attorney-client privilege with regard to the corporation. So if I work in the compliance department and other people with my same job title are non-attorneys and I am an attorney, the fact that I have a law degree does not entitle me to special treatment with regard to the things that I say or the things that I hear. Because I am performing a non-legal role, I do not get attorney-client privilege, and the SEC and CFTC will hold that against me if I try to claim privilege when they're determining what punishment the corporation should receive and what credit they should receive for cooperating. So the things you need to think about: is this person in a legal role communicating in their legal capacity, or are they providing business or financial advice? What is their job title? Are there other people that have the same job title who are non-lawyers? If so, that's a red flag, because if you are performing a non-legal role, you are not subject to attorney-client privilege. So this is a question that comes up quite often because when someone is investigated, a company, whether it's a broker-dealer, FCM, family office, hedge fund, they know that the SEC and CFTC have stated that the degree of cooperation that you provide will determine what the sanction is, but in no instance will they require you, in order to get the cooperation credit, to waive valid attorney-client privilege. However, where they draw the line is you do not get attorney-client privilege when an attorney is performing a non-attorney function or where communications do not involve legal issues such as business, such as finance. So that is something that you absolutely need to consider. If you have questions about this, leave it below. My name is Pete. I'm an attorney with 25 years experience in the financial markets. I was former acting associate director at the Commodity Futures Trading Commission, and if you'd like to work with me either as an attorney or on a consulting basis, you can find my contact info in the bio. And because I'm a lawyer, I will give you the disclaimer. The information here is for educational, informational purposes only. It is not intended to be relied on. It will not be updated. And nothing said here creates an attorney-client relationship between you and I. You should talk to your own legal counsel based on your own situation and facts, and only rely on the information and advice provided by your own attorney. So I am an attorney, but I'm not your attorney. Anyway, have a great day, everyone, and leave a comment if you have any thoughts about this, if you have any questions, or if you have any future videos that you'd like to see. Thank you.